All right, good afternoon, everyone. My name is Chad Boudreau, and I am the Chief Legal Officer of Huntington Ingalls Industries. And I have the pleasure of introducing the moderator for today's panel, the Honorable Trevor McFadden. Before I do that, though, I also have another job here today, and that is to encourage those of you who are in the in-house counsel community to pay close attention to what the Federalist Society is doing with the in-house counsel network. This is a network that started a few years ago, and it is for those of us who understand that we can get the White House right, we can get a majority in Congress, we can get everybody we need in black robes, but in corporate America, if we're not paying attention, there is a risk of undermining our constitutional republic. So we are like-minded people who want to make sure that we espouse those principles, and the opportunities that we have in this network are great. Dean Reuter has put a lot of momentum behind this. We spend a lot of time throughout the country doing different events, and they're fantastic. So we prioritize this. If you want to know more about it, you can find me, find anybody within the Federal Society, and we will make sure that you get plugged in. The Honorable Trevor McFadden is a judge with the U.S. District Court in the District of Columbia, one of the most important districts, and he is going to moderate today's panel. He's a graduate of Wheaton College and UVA Law School, and the esteemed panel today is, it's great. They're going to do everything that they can to give you behind-the-scenes look at what the administration is doing, so you get it straight from the horse's mouth. And with that, over to you, Judge.
Thanks, Chad. And I want to affirm this is the most important district in the country, certainly for you all, because you're in it right now. So expect your best behavior. Ladies and gentlemen, this panel will offer a high-level examination of the legal developments driving the Trump administration and their potential effect on business, featuring senior administration officials from the Department of Justice, the Central Intelligence Agency, the Department of Agriculture, and the Department of Transportation. This discussion will focus on the administration's policy agenda across four critical areas: redefining the federal government's role in the economy, business regulation and enforcement, national security oversight, and domestic affairs. Panelists will share their insights to outline the road ahead. Before I very briefly introduce them, let me note that their full biographies are in this handy little notebook you received when you checked in this morning. And secondly, I want to point out that I, unlike our speakers, am not in the administration and take no position on any issue. All right. I'm going to introduce the panelists in the order they're going to give their opening remarks, not necessarily where they are on the table. But two down for me is the Honorable Brett Shumate. He's the Assistant Attorney General for the Civil Division in the Department of Justice. In the first Trump administration, he was a Deputy Assistant Attorney General in the Civil Division he now leads. To my immediate right, the Honorable Stephen Bradbury is the Deputy Secretary of Transportation. He was previously the General Counsel of the Department of Transportation in the last Trump administration and held positions in the Heritage Foundation and Justice Department. At the far end on my left is the Honorable Stephen Vaden, the Deputy Secretary of Agriculture. He was previously the General Counsel of his department, and he served for the last 5 years as a judge on the Court of International Trade. To my immediate left is Michael Ellis. He's the Deputy Director of Central Intelligence. He previously served in various senior positions, including as the General Counsel of the National Security Agency and GC of Rumble, a cloud services provider. And to my far right is Ketan Bhirud. He's an Associate Deputy Attorney General. He previously served as the Deputy General Counsel of the Department of Homeland Security. So with that, let me turn it over to Brett.
Well, thanks, Judge. Thank you all for being here. It's a privilege to be with you. Thanks to Dean and the FedSoc staff for organizing this event and this panel. I'm going to talk a little bit about the civil division of DOJ, how we're advancing the President's and the Attorney General's policy and enforcement priorities, and how those are affecting businesses. First, a little bit about the civil division. You may think of the civil division as primarily defensive, and that's a big part of what we do. We defend the agencies and the great work these folks do every day, advancing the President's policy agenda, and our responsibility is to defend that agenda in the lower courts, working with agency counsel, working with the Solicitor General's office. But we also do civil enforcement work and affirmative litigation. That's a big part of what we do. We've prioritized that work, and we've actually created a new branch in the civil division called the Enforcement and Affirmative Litigation Branch to surge resources toward those priorities, which I'm going to talk about. So we have 5 enforcement priorities in the civil division that come directly from the President and the Attorney General, so I'm just going to briefly describe those. The first is combating discriminatory practices and policies in the private sector, so-called DEI. The second is ending anti-Semitism in the private sector and in universities. The third, protecting women and children from so-called gender-affirming care and child mutilation. The fourth is ending sanctuary jurisdictions and the policies that promote illegal immigration. And the fifth is prioritizing denaturalization. So just briefly, one of the main tools that we use to advance all these priorities is the False Claims Act, which touches all the agencies. The False Claims Act prohibits false claims for payment by the government. So for example, if you're a contractor and you have a contract with the Department of Agriculture and you make a false claim, that could give rise to civil liability, and the civil division handles that work. Healthcare fraud, for example, costs businesses millions of dollars every year. I've seen civil penalties up to close to $1 billion. We recover $2 to $4 billion every year for the Treasury just with healthcare fraud. If you put it all together, it's billions that we recover every year of fraud against the United States. So the claims that we pursue arise because companies who are federal contractors receiving grants, for example, make a false claim that they are complying with the law when in fact they're not, and they know they're not. Or they make a misrepresentation to the government about a fact related to a product or a service that they're providing to the government, and that turns out to be a material misrepresentation that can give rise to a false claim and civil liability, treble damages, and also an important part of the False Claims Act that we rely on is the Ketan provision, where we have whistleblowers who flag potential wrongdoing, file claims, we investigate, and we pursue those claims. I want to just briefly identify and explain 2 of those enforcement priorities. One, pursuing discriminatory practices through our civil rights fraud initiative. We're focused on representations by federal contractors that they're complying with Title VII in their hiring and promotion practices when in fact they are unlawfully discriminating based on race and sex in those practices. Second, I mentioned earlier, protecting women and children from so-called gender-affirming care. We have 30 or more investigations ongoing, pursuing all the players in the healthcare space that have participated in this practice, from the pharma companies who are manufacturing and promoting those drugs that provide so-called gender-affirming care, to the providers who provide it, to the doctors who are interacting with patients. Most of the participants that we've been working with and investigating have been participating. Others have been litigating, so I expect that to be kind of a trend going into 2026 to see how that litigation plays out. But I don't want to leave the impression that we're hostile to businesses in the civil division. We also do a lot of offensive work to identify and eliminate state and local laws that are increasing costs for businesses, that are impeding business growth. For example, in the agriculture sector, in the energy sector, we have preemption authority. We file preemption lawsuits where there are conflicts between federal legal regimes that conflict with state and local laws and policies that are impacting the policies that the agencies want to pursue. So we're identifying those practices and filing affirmative litigation. And last but not least, just to come back to kind of the bread and butter of the civil division, what we do is primarily defensive. We are working with the agencies on their policy initiatives, working with them to get those rulemakings out, and then we defend them in court and advancing the administration's agenda in that way.
Thanks, Brett. Steve Bradbury from Department of Transportation.
Thank you, Judge. Really privileged to be here. Thank you, everybody. Department of Transportation has a lot of relevance to corporate America, to the business environment in the United States, to basically the health and welfare of our economy. You may know us through some of our sub-agencies, very familiar names like the Federal Aviation Administration, NHTSA, National Highway Traffic Safety Administration, and various others. We regulate the safety primarily of every major mode of transportation in the country, but then we also support through federal funding the infrastructure for the United States transportation systems. And it's easy to see that the entire economy, pretty much the activities of almost every business in the United States depend pretty heavily and critically on the efficiency, the capacity, the safety of the nation's transportation systems. Highways, rail, trucking, aviation, critically. We see that with the air traffic control system, and you're reading about the issues right now with the federal shutdown and how that may impact the capacity and operation of the national airspace system. That's critically important for the entire economy and a major focus for the Secretary right now and FAA. The Department of Transportation has 54,000 or so employees. There's been a little bit of an adjustment in the current administration, and it has an annual budget of about $111 billion. With the in recent years, the Infrastructure Investment and Jobs Act, that funding was increased quite a bit. We had just a huge rising tide of funding for infrastructure in the United States. So with that IIJA funding in the next fiscal year, we're talking about an overall budget of close to $150 billion for the Department of Transportation. A lot of that is the Highway Trust Fund. This is money that goes out to support state and local governments in the maintenance, upkeep, and construction of highways and transportation systems. We also give grants to rail, to trucking, aviation grants to airport authorities to construct new terminals, et cetera. So all of that grant making, that funding is critically important to the infrastructure that supports the health and welfare of the national economy and probably every business that's represented in this room to one degree or another. The previous administration was rather profligate in the use of this huge amount of money and the grants that they put out, and they imposed all kinds of conditions on their grants that related to their peculiar policy priorities, including racial equity issues, climate change issues, things that were not required by statute, not even really in the statutory authority of the Secretary of Transportation. And these requirements really distracted from the efficient delivery of projects, infrastructure projects, and the money that's needed to maintain our transportation systems. They also were not terribly efficient in getting those grants out the door. I guess there's a positive to that, because they didn't all get out the door. We came into office with a huge backlog in the discretionary grants that the previous administration had announced but hadn't yet obligated. And so we had a massive chore on our hands, more than 3,200 announced but unobligated grants, really historically unprecedented. About 1,000 of them were announced just between Election Day and Inauguration Day. So in the past, that's been 50 to 100. We're talking 1,000. So clearly, something unusual going on, and it's taken us months to work through that backlog of announced but unobligated grants to really focus on ensuring that these distracting policy requirements are rooted out and that the grants really do comply with the law and advance the intention of Congress. So we're nearly done in working through that backlog. So that's a major aspect of the work we're doing. We're also taking on some big infrastructure projects like the entire rebuild of the nation's air traffic control system. Happy to talk further about that, but nothing could be more critical in terms of supporting the business environment. And then on the regulation side, we're a very active regulator, safety, consumer protection in the aviation space. And we are very focused on reforming our regulations, ensuring that they're efficient, they're complying with the law, they're consistent with a reasonable interpretation of the Secretary's authorities, and they're not overly burdensome in an unnecessary way to the economy. And just to highlight one big example, we're working on a complete reset for the nation of the corporate average fuel economy standards, the CAFE program, and that will be coming out in a matter of weeks, our proposed reset of all those fuel economy standards, which were really abused and misused by the previous administration to try to force an artificial acceleration in the transition to electric vehicles. A complete, I think, betrayal of really what Congress intended in the program. So that's an example of a major regulatory reset that'll have huge repercussions for business across the country. So I guess I'll end it there. Thank you, Judge.
Thanks, Steve. Now, Steve Vaden from Department of Agriculture.
So at USDA, we're in the midst of everything that you can think of under the sun. From helping the president and his team negotiate new trade agreements, many of which have come to fruition over the past couple of weeks, to working on important deregulation, to right-sizing the department in order to meet the needs of the constituencies that we serve, almost none of which are located here in Washington, D.C. When I left the Department of Agriculture in 2020, we had an annual budget of approximately $150 billion. When I returned to the Department of Agriculture in July of this year, its budget had ballooned to $220 billion, an increase of $70 billion, or almost 50%, and nearly all of that was because of increases in food stamp benefits put through by the previous administration. At USDA, we are working to bring our budget back in line with the reality of congressional appropriations, and we're working to get out of as many producers and rural Americans' way so that they can continue to make our economy hum without too much government supervision. One of the first things that we're working on is a reform of NEPA. NEPA has gotten in the way of too many projects, and particularly for our Forest Service, we have had an increase in forest fires because of our agency's inability to have staged wildfires and also to do treatments on the national forest land, because every time we decide that we want to cut a tree, even if it is a dead one, and I'm not making that up, we get sued and sub-judge in the Ninth Circuit enjoins us. And the result of that is what you saw in California earlier this year, even though those were not federal lands. If we can't treat our national forests and see to it that they are healthy, the result is that property is destroyed and people die. And it is needless and unnecessary and definitely not required by any law that the Congress of the United States passed. And so therefore, we are working to return NEPA to its actual statutory foundations, which is for the agency to describe the reasons that we think a project is a good idea and the environmental effects thereof, to take comment from the public and then respond to that comment and move on. I am happy to see that the federal courts, and in particular the Supreme Court, have begun to realize that NEPA is a huge problem, with their recognition in the 7-county case that far too many federal judges were moonlighting as administrators of the Environmental Protection Agency or some other agency and coming up with all kinds of questions that the agency involved had no jurisdiction to handle for the agency to answer before it could move forward with its chosen policy. But this is not just a problem in the environmental realm, it's a problem throughout all of administrative law. For example, during the first term when I was general counsel at USDA, we moved forward with a deregulatory rulemaking to make it easier for our meat processing plants to process more carcasses per hour. That was struck down by a judge in the District of Minnesota on the grounds that we did not adequately consider worker safety, despite the fact that USDA has no jurisdiction whatsoever over worker safety. That is the Department of Labor and its Occupational Safety Health Administration. I am happy to say that in the 7 counties case, 5 years later, the Supreme Court decided that I was right and that we don't have to talk about worker safety. So we are now moving forward with that rulemaking proceeding to try to make our plants more competitive with their foreign counterparts. Because here's the perverse part that so few people talk about, including those who allegedly were concerned about worker safety. Their socialist brethren in Europe allow their meat processing plants to operate at an even higher capacity than that which will be proposing in a coming rulemaking. So what's the issue we're really concerned about? Second, we are working to right-size our footprint and get in line with what should be a rational budget amount for the United States Department of Agriculture. Earlier this year, the Congress passed a law called the Use It Act. It requires that any space that is occupied, owned or leased by a federal government agency must be at least 60% occupied, or the agency should consider giving it up. Now first, note the low bar, 60%. We're at the in-house council conference. You guys work for private sector businesses that answer to boards of directors and shareholders. If 40% of your real estate was vacant, something tells me that you would have a lot of questions to answer with your board of directors and shareholders. And yet, that is our goal in the federal government, for only 40% of our footprint to be vacant. And despite that low bar, every building that the Department of Agriculture has in Washington, D.C. and its environs, including the ones that you pass every day on Independence Avenue, cannot meet that metric. The South Building, which until the construction of the Pentagon was the world's largest office building, on its highest attendance day, a building that can house more than 7,000 employees, was only at 39% capacity. And that building alone has a backlog in maintenance of more than $1 billion with a B dollars. To show you how bad it has gotten, if you go to Beltsville, which is the home of our Agricultural Research Service in suburban Maryland here, there are more than 400 buildings on that campus, which encompasses dozens and dozens of acres. Of those more than 400 buildings, which I have toured, more than 250 of them are in such appalling condition that they are waiting to be torn down. They have been abandoned, they are empty, and in a few cases, there are literally trees going through them. And yet, I had to appear before a committee of Congress to explain to them, number one, you passed this statute a few months ago, and we intend to follow it. And number two, we really don't think it's a good idea for our employees to have to report to locations where, and again, I am not kidding, we are running buildings based on a steam plant, and the pipes are leaking so that when you go down into the bowels of the building, there is literally steam pouring out in the basement, leading to mold and flooding issues. So this is a waste of taxpayer money. It's a danger to worker safety. And there's nothing rural in Washington, D.C. to begin with, so why in the world are we here? And so what we have proposed to do is to take most of our employees who are here in Washington, D.C., and to move them somewhere closer to where there actually are people in rural America. We did this with 2 entire federal agencies in term 1, our Economics Research Service and our National Institute of Food and Agriculture. So in term 2, we're going bigger. We're taking nearly the entire agency and getting it the hell out of here and moving to North Carolina, Indiana, Missouri and Kansas on the border there in Kansas City, Colorado, and Salt Lake City. And those will be our new hubs where most of our employees will be. And at the end of our relocation, we expect to have saved the taxpayers approximately $2 billion. Every building that we will be moving into is a building that you, the taxpayers, are already paying for and which are already to be moved into, including in many cases, the wiring is hanging down from the ceilings. All we need is furniture. I've toured these places. They're much more modern. They are wonderful places to live, and I'm actually thinking of relocating myself there because apparently if I go to Raleigh or Fort Collins, I get a free gym membership included once I move my office there. And so it makes sense from a policy perspective. It definitely makes sense from a perspective of the taxpayer, and it's moving our agency closer to the communities that we serve. And finally, I would be remiss if I didn't say something about the food stamp program, because it has very much been in the news. It is a truism that the SNAP program helps many people in this country who otherwise would have difficulty eating. However, it is also true that over the past several years, the program has ballooned to where nearly 1 in 8 Americans receives a benefit on an EBT card. Many of those people are qualifying without having gone through a proper check of their assets or their income. And we have recently received data from nearly half the states which reveals a fraud rate which is truly disturbing. And the data that we have compiled from the states that have cooperated, which does not include at the moment California, New York, Illinois, or such places. I can only imagine when Brett gets us that data, what we're going to find at that point. But just to give you a few examples, we have one gentleman who is receiving simultaneously food stamp benefits in 6 different states. We have hundreds of people whose cards are being used. They are active, but they have current balances on their EBT cards of more than $15,000. The money carries over if you don't use it. We have one person, truly a champion, who has a balance on his EBT card of more than $85,000. And this is your taxpayer money that is being taken from you. And this is what we are finding as we are getting the actual data from the states that show who is receiving this and what they are or are not doing with it. The taxpayers have a right to know what is being done with their money, and a program that when we have appropriations, we are spending more than $9 billion a month to fund. And they especially have a right to rest assured that only those who are truly needy are benefiting from the program, because every dollar we give to someone who has a balance of more than $15,000 on their EBT card cannot go to someone who is truly in need and would not eat without the benefit. And that is what Secretary Rollins and I are committed to doing. We are going to get the data from New York, California, and Illinois. We are going to go through that data, and we are going to do what we are currently engaged in with states like Texas, Tennessee, and Florida, and root out this fraud. Thank you very much.
Thanks, Steve. We'll now hear from Michael Ellis from the CIA. I'm very excited about this. This is maybe the first person I've ever spoken with who will admit to being part of the CIA, and I'm pretty sure he's not going to kill us afterwards. So, Mr. Ellis.
Thank you, Judge. And good afternoon, everyone. It's a pleasure to join this distinguished panel. At first blush, you might wonder why the Deputy Director of the CIA is sitting on a panel about the nexus of business and government. After all, we aren't an enforcement agency. We don't really regulate the private sector, and in fact, by law, we don't have any internal security functions. Plus, aren't we usually supposed to be walking around foreign capitals, wearing trench coats, maybe a fake mustache? So that is the bread and butter, although we have better ways of concealing identities these days. But CIA's mission relies on much more than stealing secrets from our adversaries. The world and the threats we face have grown increasingly complex. And for CIA to succeed, we have to adapt our approach to these new realities. And one of the ways we're doing that is by deepening our relationships with the private sector. So to explain that a little further, I will point to our most pressing strategic challenge, which is China. It's no exaggeration to say that China poses a truly existential threat to U.S. national security. And that threat is dramatically different from what we faced from the Soviet Union during the Cold War. Obviously, there are military and geopolitical challenges with China, but China also poses an economic danger to our nation in a way that the Soviets never did. Our industrial supply chains were never intertwined with those of the Soviet Union, and the Soviet Union never held near total control of the world's critical natural resource supplies. And these threats compound each other. When you look at the recent Chinese export controls on rare earth minerals, it's both an economic and technological danger to the United States, which threatens our defense industrial base, our consumer economy, and our ability to conduct scientific research. On top of all of that, China has the advantage of directing both public and private entities towards its goals. There isn't really a huge distinction between private enterprise and government. In some sense, you could say that there really is no private enterprise in China, no true private enterprise in the way that we would understand the term. So as a result, China can leverage business almost at will to pursue national security objectives. Now, obviously, we have a very different system here in the United States, and despite what the movies and television shows might tell you, the CIA always operates in adherence to our legal system. But we do have a unique mission and carry unique statutory authorities, and those do allow us to partner with the private sector. And really, since the founding of CIA in 1947, there has been a partnership between the CIA and American businesses to advance national security. Private sector innovation is, and the freedom and creativity of our system is a key strategic advantage we have against China. Frankly, our corporate world can drive change at a pace and scale that the government will never be able to match. So at CIA, we know this well, and we are working diligently to leverage all of our authorities to work with the business world. For example, we work with an independent nonprofit venture capital firm, In-Q-Tel, that facilitates investments in national security and defense technologies. You probably use In-Q-Tel products, In-Q-Tel success stories every day. For instance, Google Earth software, where the cybersecurity firm FireEye stemmed from In-Q-Tel investments. We also have CIA Labs, our in-house R&D arm, that partners with other research facilities, academia, and industry on technology from AI to biotech and quantum computing. Really everything that China and our adversaries are trying to aggressively master and deploy in their efforts to undermine the United States. That said, there is much more that CIA and the intelligence community needs to do, and our historic ways of partnering with the private sector will not be sufficient to meet this national security challenge. That's why Director Ratcliffe and I are making clear that CIA will partner with Wall Street, Silicon Valley, and the many startups in between to partner as part of our mission, and this part of our mission is equally as important as recruiting spies or carrying out covert activities. At the same time, CIA has attorneys to ensure that we perform our clandestine activities lawfully. We also need to partner with attorneys in the private sector, in the corporate world, and all of you in this room, to ensure that our business partnerships are above board and that they are doing all that they can do to advance national interests. American business really can't stand on the sidelines in this competition of China. It's just it's not a choice. There are no non-combatants at the end of the day, because the adversaries will not let our businesses refrain from the competition. In the cyber security realm, in the physical realm, China is attempting to gain advantage from our private sector, stealing American intellectual property, conducting economic espionage against our domestic industry. And as a result, because of this danger, cooperation between our private sector and public sector has to happen for the good of every American. Now, in the first Trump administration, when I was serving in the White House counsel's office and the National Security Council, we saw this need coming. We started to take action, but now we're charging full speed ahead to make it a reality. And with that, I'll pause and look forward to discussing more in Q&A.
Thanks, Mike. All right, and finally, Ketan, who advises the Deputy Attorney General on issues involving antitrust, energy, natural resources, tax, and civil rights.
Thank you, Judge McFadden. It's great to be here. And so my colleagues have talked about their agencies and their priorities, but I was asked to do something a little bit different before we get started. And that's kind of provide you with a framework for how these priorities actually play out in practice. And so I thought I'd start by talking with a problem that I see happen quite a bit. And so I'll see a company that'll spend millions or tens of millions on fancy DC lawyers, and then they'll go to a federal agency like the Treasury, and they'll get the Treasury to implicitly bless their business structure. And then they'll go to the SEC, and they'll go get another regulatory agency like the SEC and get a no action letter, and then they think they're all set. But really, they're not, because what happens 6 to 12 months later is the Kansas and the Tennessee Attorney Generals have issued CITs, the FTC starts investigating, and then a couple states like Texas and Florida start passing laws to make their entire business model illegal. And so the question is, how does that happen, and what mistakes have these companies made to get them here? And I think there's two main mistakes they make. The first is they think there are kind of these imaginary lanes in government where each of the agencies stays in their own lane and companies only need to be concerned with their primary regulator. The other mistake that I think that they make is that they think all of us agencies are on the same page. And so there's like some weekly meeting where we all get together and decide how we're going to treat Amazon or whoever it is and make sure it's exactly the same. And, you know, I will tell you, we have meetings, we have policy coordination committees, we have all these different things, we have formal and informal calls, but we're just not always on the same page because it's hard to do. And so there's a few different ways to look at these issues, but the way that I kind of like to think about it is I think that there's 3 layers of government. And so the first is the president, the second are the federal agencies, and the third are the states that can either amplify or obstruct what we're doing at the federal level. And so I'll take them one at a time. And so the president is obviously the most important. We have a unitary executive. You know, we talk about it in all the agencies at DOJ. We have an audience of one. The president is the executive branch is the president. So when the president speaks, everybody should listen, and they do. Right? So when the president says he wants to unleash American energy or he wants to win the AI race with China, people should listen and people should know that's what we're going to do. But the critical mistake that I think most companies make is thinking that this is policy, because it's not policy, it's aspiration, right? And so what I say is you should think of when the president speaks, the presidential direction more as your compass, not your map. Right? So it tells you where we want to go as an administration, but it doesn't tell you how or even if we're going to get there. But you can, you know, look at who the president appoints, what he's asking for in his budget request, what he's saying over and over, because if he just says something once, maybe it's not as important as something he says 10 times or something he says 10 times a day, like secure the border. And whether or not it's, you know, it's kind of funny, but an executive order versus a Truth Social post. I can tell you I've read every Truth Social post that the president has posted. I pay attention to them, but for the executive orders, every single one I've read, every one that applies to DOJ I've read multiple times, and we track to make sure that we're implementing everything in those executive orders that the president wants. So that gets me to the second layer, the federal agencies, and I say that's where that aspiration becomes reality, right? Your alphabet soups of agencies, all of us up here, the SEC, FTC, DOJ. And here's where we try to take the president's priorities and turn them into enforcement, regulation, or whatever you have it. And the problem, though, the problem for us and the problem for you is we often disagree on how to turn the president's agenda into reality, right? So even with clear presidential direction, agencies have their own leaders, their own cultures, and their own statutory missions that all ultimately influence how we carry out that mission or carry out that agenda. And so the example I would say is just at a high level, take the crypto industry, right? The president has said he wants to make America the crypto capital of the world. But the SEC could see an unregistered security, the CFTC could see it's a commodity, Treasury can see compliance risk, and IRS with every industry wants its tax revenue. So if you're a company in that industry, you need to think about all the different enforcers, right? Because you could buy peace with one and still have problems with 3 others. And so what I would say at this level is what you're trying to do is figure out if the agencies are on the same page or if they're on different pages, right? If they issue joint guidance, that might suggest that they're working cooperation, like the USDA and we have on some of these antitrust issues. Or are they making separate contradictory statements? And then the last layer, I'd say the third layer, is the states, right? And this is the one that tends to trip up the people in this room the most, because here in DC, we forget states exist and state AGs exist, but there's 50 state AGs, hundreds or thousands of different state regulators, and none of them work for the president, and they have their own agenda. And so what I'd say is they do two things. Either they can amplify what we're doing, or they can obstruct what we're doing, right? And so when they're amplifying what they're doing, sometimes it's as simple as they're sending a letter in support of what we're doing, or sending letters to companies. But on the other side of it is they can open up their own parallel investigations or enforcement actions under their own law, and that's when they're the most effective in amplifying what we do. And the example I use is with DEI. Look at what happened. So over the last 4 years, this country was going in the wrong direction, with so many companies adopting racist, unlawful DEI policies. And on day one, President Trump issued an executive order. Weeks later, on AG Bondi's first day in office, she issued a memo saying we were going to get rid of it and laying out how we were going to do that. And then the cascade followed. The Texas AG, Ken Paxton, started launching investigations. Over a dozen other Republican AGs joined suit. And within 90 days, at least from what I understand, 1 in 5 companies in America had abandoned these DEI programs, including some of the biggest companies in the world like Walmart and Target. Now, the other side of that is some of these state AGs and state regulators try to obstruct what we're doing, and they call themselves the resistance. And so functionally, what they do is they sue to block what we're doing, or they try to pass their own laws to contradict it. And the example I use in energy, right? The president said he wants to unleash American energy, but California and other states are passing every law they can to make fossil fuel expansion impossible, and states like New York are denying every permit they can. So even if you have the green light at the federal level and find somewhere to drill, you might not be able to transport it. And so the thing I'll finish up with, I'll just say is, when you're listening to us about what our priorities are, you should also be thinking about how they're going to play out. And again, there's many ways to do this. I think there's 2 key questions I would look at is, first, where do these layers conflict, right? And which agencies actually have enforcement power? If DOT says your project's fine, can the EPA say no? Probably happens a lot, right? And then the second question is, how are the states going to respond? Will they amplify what we're doing, or will they obstruct it? And in those differences, you can find your allies and potential risks. And thank you.
Thank you, Ketan. And I actually wanted to pick up on something you just mentioned. In 2024, the Supreme Court struck down affirmative action in higher education in Students for Fair Admissions versus Harvard. That decision's ramifications are now being worked out far beyond higher ed. I'd be interested to hear about how some of the other agencies represented here are applying that decision, if at all. Steve, do you mind starting us?
Oh, sure. Thanks, Judge. Well, one of the things we are required by statute to do in all of our grant programs I described earlier is to allow states to presume that a minority or woman-owned business is disadvantaged for purposes of getting essentially a preference in contracting, the Disadvantaged Business Enterprise Program. And it's actually in statute for us to presume that, and the states need to presume that, and they set goals and allocate grant money to subcontractors essentially based on the race or the sex of the owner of the business. Clearly, as the Supreme Court has emphasized in the Harvard case, there's no doubt about it, this is unconstitutional. You cannot have a presumption in federal law or state law like that. And the Solicitor General has notified Congress that the Trump administration views that as unconstitutional, is not going to defend that statute in court. The Attorney General made it very clear, the President in his executive orders. So we have amended our regulations implementing the Disadvantaged Business Enterprise Program, and we've notified all recipients of grant money across the country, all the states that administer transportation programs with our money and do this subcontracting, that it is unconstitutional, it's against federal law to award these contracts based on the race or sex of the business. And we are in the process of reviewing all those programs across the country, reviewing what every state is doing, and purging the racial discrimination and sex discrimination out of the system. It's not going to be easy. It's very entrenched in a number of states with a number of big projects, but that's something we're very actively doing. And then just generally, as I mentioned earlier, removing from all of our grant agreements the racial discrimination, the racial equity requirements, the policy preferences that the previous administration putting in, and making it clear that racial discrimination in all of its forms is inconsistent with federal law, federal policy, with the Constitution. And so this is a big job, but it's an example of, I think, the president making it clear, as mentioned on day one, that this is inconsistent with federal law, inconsistent with the policy of this administration. And it's not just changing the conduct within the executive branch, within the federal government, but also using our powers, using every lever we have to project it out into industry, into academia, because the education department gives lots of grants too, and really changing the culture of the country. And I think you see it happening. The tide has turned, really, when it comes to DEI, racial preferences, racial discrimination. It's true in climate change as well. It's amazing what difference an election can make and having the right president in office.
Steve Aden, do you want to speak to what's happening in the Department of Agriculture?
Yes, unfortunately, during the prior administration, USDA was a leader in DEI, and it reached truly absurd results. Most notably, there were a number of natural disasters which affected America's farmers and ranchers in 2023 and 2024. Congress appropriated monies to help farmers recover from things like droughts and floods. And when the prior administration administered those programs, it put in place something that it euphemistically referred to as progressive factoring. That is to say, if you were a rancher in Texas and you were white and your fellow rancher next door were black, and both of you experienced the same types of harms from the same drought that struck Texas in those years, your black neighbor would receive more in disaster relief money than you would solely because of the color of his skin. The same would be true if your neighbor was a woman rancher as opposed to you, a male rancher. Again, same natural disaster, same harm, distinction solely based on race or gender. This is abhorrent to everything that is contained in the 14th Amendment to the Constitution and absolutely at odds with our founding principles and the Declaration of Independence. USDA was rightfully sued during the prior administration for administering programs such as these. Some of you are probably aware of the fact that the prior administration had as a policy goal to relieve the debt burden of every African American farmer in the United States, to cancel all of their debt to USDA. No other race was going to receive this preferential treatment. It was limited to black and minority farmers. White farmers were out of luck. That too was enjoined by no fewer than 4 federal courts around the country. As a matter of fact, it was enjoined so quickly that not a single dollar got out of the program. We have ripped all of that out of regulation. We put a regulation through that took it all out. The problem that we have at USDA is that the Congress, in its infinite wisdom, wrote some of these racially discriminatory provisions into law. So we have statutory requirements with regard to some of our farm programs that we are to discriminate on the basis of race and gender and give people more benefits in some programs solely because of those immutable characteristics. We are working quite closely with Brett and his team at the Department of Justice. to handle some lawsuits which quite rightly challenge these unconstitutional preferences. And it is my expectation that at the end of the day, the courts will strike these unconstitutional statutes from the book, and USDA will once and for all be out of the business of dividing people on the basis of race and gender.
Brett, do you want to?
I need a mic. Okay. So with the False Claims Act, we have the opportunity to look backwards. And as I mentioned, we have the Civil Rights Fraud Task Force that we are looking at companies who have engaged in hiring and promotion practices that unlawfully use race and sex as a factor in those programs. I think the Harvard case should have put a lot of companies and universities on notice that racial discrimination is illegal if it weren't already clear. So that's something that we're looking at. The Harvard case is an important component of that. So to the extent companies were certifying or universities were certifying that they're complying with Title VII post-Harvard, I think that would create significant exposure of False Claims Act liability.
Many of the people in the audience will be familiar with CFIUS, the Committee on Foreign Investments in the United States, an interagency body that decides whether foreign companies may pursue investments in U.S. companies considered important to national security. I wonder if there's a CFIUS-like role for other agency regulations that touch on national security. Perhaps that's already happening. Mike, could you speak to that?
Sure, and there was some momentum at the end of the first Trump administration towards we call it like an inbound investment regulatory regime. An outbound investment regulatory regime, pardon. Because CFIUS covers only investments into the United States, but realizing that U.S. companies making investments in certain key areas outside the United States can also pose national security consequences, right? If a leading American tech company is going to build an AI training laboratory inside of mainland China, right, that there will be national security consequences, and this is something that where there is an appropriate role for government, almost like a reverse of CFIUS. And CIA participates as part of the intelligence community in that CFIUS process. But I think that there are going to be a whole realm of areas where the mantra that economic security is national security plays a larger and larger role. You can start to see that with the recent arrangement, the recent deal between the War Department and a critical minerals company called Mountain Pass in California, where in exchange for an investment where the Pentagon took an equity stake in Mountain Pass, they also provided a guaranteed offtake agreement. So they agreed to purchase certain quantities of critical minerals processed by Mountain Pass at guaranteed prices for a certain duration. And that's because in the past, when the Chinese had imposed export controls on rare earths and competition in Australia and Japan, when competitors tried to circumvent those export controls, the Chinese would flood the market intentionally flood the market with whatever the competitor tried to process to effectively drive them out of business by undercutting them on price. And then after the competitor was out of business, then resume the strangulatory export controls. So to get around that issue, that's why you see the War Department taking both an equity stake as well as that guaranteed offtake agreement, playing a larger role in the economy than I think has traditionally been the case, or that many folks would have been traditionally comfortable with, but doing so in response to a clear national security challenge and in recognition of the fact that these challenges will require a different response from the government.
Ketan, have you an aspect or a viewpoint on that?
Yeah, so my bias is that I always think we should have the least amount of government possible, and so something as formalized as requiring a CFIUS approval in this context, I don't think would be necessary. But I would think something like that, or at least some sort of interagency group that would help us get a better handle on national security issues in other contexts, would be very helpful. I can tell you, as I sit at DOJ, I have to take meetings with companies all the time where they think that, it's going back to what I said, people listen when the president talks, right? And so they're like, okay, if I use these magic words, will they let my merger go through? If I use these magic words, or I'm gonna get out of this enforcement action. And one of those is that this national security issue comes up all the time. And so I take the meeting and I meet with whoever it is and they say, well, our company is so critical to your national security. And I say, great, have you talked to Michael Ellis at CIA? No. Have you talked to anybody at NSA? No. Okay, what evidence do you have? Well, we sell a lot of software to DOD. Great, how much software do you sell to DOD? Well, we don't really know how much we sell. And so, I think it would be helpful if we were able to, as a whole of government, have some clearinghouse for better understanding this. And so I actually knew if Michael at CIA or NSA or somebody had concerns, rather than, companies being able to come up to me and them wasting our time and us wasting their time.
We talked about the Harvard affirmative action case. Another big Supreme Court decision that's happened since the first Trump administration is Loper-Bright, in which the Supreme Court held that Chevron deference no longer applies to reasonable agency interpretations of ambiguous statutes. Most of the panelists were in the last Trump administration. I'd be interested in how you've seen Loper-Bright impact your regulations, your litigation position, and your interactions with the business community since the last administration. Brett, do you want to start?
Sure. From my perspective, Loper-Bright has not made an impact for two reasons. Number one, the Trump administration, past and present, has never enjoyed the benefit of Chevron deference. Courts just did not defer to the Trump administration. And second, the cases that we've had in this term since January have mostly been presidential action cases where Chevron would not have made a difference, or agency grant cases, which are just different types of cases. We haven't had the flood of rulemaking cases where you would typically have a Chevron defense to a challenge to the agency's regulation. So I think it remains to be seen, Judge, how that will play out. But I think it'd be interesting to hear from the agencies, because I think from my perspective, it would probably change the way agencies write rules, because the agencies need to get the question right. They need to correctly interpret the statute for the regulation to be upheld in court.
Steve Bradbury, you want to?
Yeah, I'd be happy to jump in on this. We championed in the first Trump administration something that I like to call the rule on rules, which is a template of procedural requirements for approaching rulemaking, and it's kind of caught on. We're reinstating it now in the second Trump administration, and it's a kind of a good guideline for responsible rulemaking, I think, across the government. But one of the principles of that always has been, since the first Trump administration, that we will interpret statutes based on the best reading of the statute, and we're not going to attempt to expand the jurisdiction or authority of the agency beyond what a reasonable interpretation of the statute, really the better interpretation of the statute, provides for. And in fact, we made it explicit in our rule on rules in the first Trump administration that we would not use doctrines of judicial deference like Chevron as devices to expand or push the bounds of the agency's authority under statute into new areas. Now, I will say that the previous administration, I think, very clearly did do that. And I would use as a good example the CAFE standards I mentioned, the fuel economy standards, where they were using a program that Congress set up in order to create feasible and practicable fuel economy requirements for internal combustion engine vehicles. It really is expressly meant to apply to vehicles that run on gasoline or diesel fuel, and not to take into account the fuel economy of electric vehicles or other non-traditional automobile engines or forms of locomotion. But it was very clear that the previous administration was setting those standards explicitly at a level that was truly impossible to meet for internal combustion engine vehicles, for the purpose of forcing the auto industry to shift to electric vehicles, because the standards apply on a fleet-wide average basis. So they set the average at a level where you'd have to transition a certain percentage of your overall fleet to electric vehicles to meet President Biden's goal of a certain percentage. And the EPA did that as well. I think those are examples of the misuse of statutory authorities in ways that clearly go beyond what Congress had intended. I would say they raise major question doctrine type issues, but at a minimum, clearly trying to take advantage of judicial deference doctrines like Chevron to push the bounds of what's allowed. So I don't see the demise of Chevron as raising, as I agree with Brett, any significant crimp or cramping of our style or our ability to regulate as we see in accordance with the president's agenda, because we're going to reform these programs to stay within the traditional bounds of what Congress was intending. Much more modest approach to regulation makes a huge difference. We expect our reset of the corporate average fuel economy standards to achieve something on the order of $100 billion in cost savings for the U.S. economy. So it makes a huge, huge difference, and it will for businesses across the country. But it's just a matter of following the law and being much more modest in how we use the authorities that Congress has given us.
Thanks. Let me so we've got a few minutes left, and I'm happy to take some questions from the audience. We've got a microphone right there. While you all are thinking about potential questions, which I want to remind you are short and end with a question mark, let me ask how the shutdown is affecting your agencies. Ketan, do you mind hitting that briefly?
Yeah, I guess quite a bit. And so at least with DOJ, most of the agency is furloughed. The exemptions are generally for people who are dealing with criminal, national security, things like that. Very little of civil is exempted. We have, things. But I would say, I shouldn't say this because there's going to be people who like hearing this, probably not in this room, but it's hard for us in administration to get anything done during the shutdown. There's so many of the people who are out, and even those of us who are in, there's most of the things we're working on, at least that are civil, we're not able to work on, and we don't have the resources or the help to get it done. So hopefully this ends fairly quickly.
So, Steve, I know the question everybody has in the room is, are they going to be able to get home tomorrow? So maybe you can speak to that.
Well, we do have 14,000 air traffic controllers working without pay right now for the American people. They're dedicated professionals. It's a very important job, obviously, keeping the national airspace system running. But these are human beings with families and expenses. They have to put food on the table. Incredibly stressful for them, and many of them having to take second jobs, working in the gig economy to try to keep some income coming in for the family. So it is affecting staffing. You've seen the Secretary talk about it, the Administrator of the FAA. And so we are, as we've announced, going to be taking some action to reduce capacity across the national airspace system to accommodate these ups and downs in staffing and to continue to ensure safety in the national airspace, which is the top priority. So very, very unfortunate that it's happening. That's probably the biggest impact, DOT, from the shutdown. I mean, we do have different funding streams for different components of the Department of Transportation. The Federal Highway Administration, Federal Transit Administration, they operate with funding through the Highway Trust Fund, and it's not affected by the lapse in funding. So we're continuing to operate in certain areas, but as Ketan mentioned, with our interactions across the government with other agencies where we depend on approvals in the interagency process, et cetera, things are having to slow down. But obviously the air traffic control system is our number one focus right now. And there will be, it's unfortunate, but there will be delays in the system. But safety is obviously paramount.
And if I could just add to that, I'd echo Steve's points about the dedicated professionals we have at CIA. Most of our employees are essential and are working without pay right now. I do fear, though, that the longer the shutdown continues, the more strains we'll see on national security, because while our officers have been committed to mission, they've been getting the job done and collecting the intelligence needed to keep Americans safe. The longer they go without pay, the longer we aren't able to expend funds for critical mission needs, the greater the danger becomes.
So what I hear from Steve is, I hope you all enjoy DC. Any questions from the audience? Yes, sir.
Yes, sir. I have a question. This is mostly for Mr. Shumate. I was curious if you could speak to agencies that have independent litigation authority, how you work with those agencies, and whether that authority inhibits DOJ's ability to have a unified litigation strategy in support of the president's policy priorities.
So great question. I think the main focus of our attention has been defending a lot of the cases where the president has removed principal officers with removal protections at the independent agencies. I think it's really challenging when you have multi-member commissions for the White House to control them, to direct policy making. It's not really my wheelhouse, the policy making realm, but from a litigation perspective, a lot of these independent agencies have their own independent litigation authority where we don't see their briefs, we don't control their litigation. Maybe that will change in the future if all these removal cases turn out in the president's favor. But I think a real focus of our litigation this past year has been the president's Article 2 power to control the executive branch. And the kind of the seminal cases are like the Slaughter case, the Cook case, which are now up at the Supreme Court. So we'll see what the Supreme Court says.
Yes, sir.
Clark Forsyth, Americans United for Life. Do you think Congress will attempt to broadly preempt state AI regulations, and isn't it possible to protect national security without broadly preempting state AI regulations?
Do you want to go first?
Well, as to a prediction on whether Congress will preempt it, I know there's been some discussion around it. I don't think there's been any conclusion on that front. To your question, the second part of your question as to whether such preemption would be necessary to advance national security, that's certainly an argument that many of the leading AI companies make, that if they are subject to state-by-state regulation across 50 different jurisdictions, that they will be unable to keep pace with their Chinese competitors. And certainly, I would agree with the importance of maintaining a technological edge over China. Certainly, our companies are national treasures in this respect. As to the empirical analysis, though, on whether these regulations at a state-by-state level certainly make their life more difficult. I understand that point. Whether the argument is as strong as opponents of state-by-state regulation make it out to be is harder to say.
Well, for example, 45 states have passed regulations prohibiting or regulating AI's use for producing child sexual abuse material, CSAM. Isn't it possible for the states to do that without affecting national security or our competition with China?
Yeah, and I can think, I guess, in other contexts, there are pretty wide agreement among companies. I'm thinking back to my past service as the general counsel of a video sharing platform, Rumble, where even CSAM material is the one area where there actually is an affirmative duty on companies to moderate content and to report it to the government, through the NCMEC. So there might be a CSAM exception here in some degree, where tech companies are already pretty familiar with regulation in that area and pretty familiar with how to apply it. But when we're talking about different, California and Texas and Florida and a dozen other states all imposing slightly different, possibly conflicting regulatory regimes, I can see an argument for preemption in a broader sense. But again, whether that argument is as strong as some make it out to be is less clear to me.
Great.
Thank you.
Did you want?
Yeah, I guess what I would say on that is I don't think I'm revealing any state secrets here, but we've had multiple interagency meetings on how to deal with AI and the national security threats, and it's just a hard issue because there's so many different opinions, even, you know, within the Republican Party on what we should do. And so I think it could make a lot of sense for Congress to step in, but, you know, I think there's an inverse relationship between Congress's willingness to step in when it should and when the issue is complicated. So I'm not optimistic that at least anytime soon we'll see Congress stepping in to fix what I think they should.
You know, Barney Frank, well, I don't agree with him on much, used to joke that Congress only has two speeds, way too slow and way too fast.
Yeah.
So, you know, maybe it's in the way too slow speed right now, but it can always toggle.
Yeah. So we talked a couple ways that this administration, comparing this administration with the first Trump administration. My recollection is in the first Trump administration, there was a 2 rules out for 1 rule in guidance from the White House. Is there a similar standard today?
Yes, it's now 10 for 1. Yeah. So that kind of gives you probably a nice little rule of thumb comparison between the gear we're in the second Trump administration versus where we were in the first. First was amazing. It was a great experience for me to be in it, but wow, this administration, the second Trump term, we're like operating on another level. And I think we learned in the first Trump administration that the 2 for 1 was super easy to meet. It was almost a nothing burger in terms of what we were doing on a regulatory reform at Department of Transportation. And I anticipate that 10 for 1 is going to be no problem. We're basically right now at more than 100 to 1 at Department of Transportation because I tell you, it's the 1 is a new significant regulatory rule. So that's a new regulatory requirement being imposed that has significant impact and is identified as significant by OIRA, Office of Information Regulatory Analysis. And those don't come along every day. And then what you're comparing it to, the 10, is not significant deregulatory rules, but rather any deregulatory action that removes a regulatory requirement. So it could be a change in one phrase in a regulation, for example. So any regulatory action that overall is lessening the burden or the cost of regulation, deregulatory, is compared to one significant new regulatory burden being imposed. And we're going through the CFR, Department of Transportation, making hundreds of rulemaking actions that reduce or eliminate unnecessary regulations, rationalize them, things that are outdated, et cetera. Every single one of those actions, and we're doing hundreds and hundreds of them, is a deregulatory action. And so the 10 for 1 is not going to be and it's certainly not going to impede our ability to continue to regulate as necessary to preserve and enhance safety in transportation.
Great. Thanks. Well, we come to a new and very exciting part of the presentation. Before we came up here, I was handed an envelope from Dean Reuter with instructions, please open and announce message at the conclusion, underlined twice, of the panel. I feel a little like the Oscars. I was hoping that this was going to be a vacation in Florida, but Dean told me it is not. All right. Imagine a drum roll in your minds right now. There we go. All right. Oh, here we are. At 1:30, Justice Amy Coney Barrett will be signing copies of her new book, Listening to the Law. Copies will be for sale on the concourse level outside the cabinet room where the signing will occur. The signing will conclude at approximately 3 p.m. There you have it. Ladies and gentlemen, please join me in thanking our terrific panel.